All right. Welcome back. Welcome back. It's May 13th, Thursday. This is another episode of the Economic Justice Law Review, the EJLR Weekly Scholars Review. I'm your host, Andre Smith, Smitty Fontan. You know me. 15 years at Widener, Penn State, Howard, Florida International University, right? Tax law and all administrative law, but you know my thing is economic justice. And the framework, and here at the EJLR, the Economic Justice Law Review, we're not producing original scholarship. We are collecting and becoming the repository for scholarship on race, economics, and law that's published in the journals all around the country. So every week we're going to go pull these articles, these fantastic articles published by you wonderful scholars out there, and recharacterize them in terms of economic justice. Some of them will expressly talk about economic justice, but for those that don't, criminal justice, healthcare disparities, something that we're going to talk about today, we're going to recharacterize them in economic terms. It is my belief that almost every racially subordinating dynamic can be recast in terms of its denigration of the free market. Why is that important? Because on the one hand, it describes denigration today, right, or degradation or subordination today, but by showing how it denigrates an otherwise free and fair market, it shows how these circumstances today will perpetuate racism and exacerbate the racial wealth gap in the future. So we do this with an analytical framework called racially asymmetric market imperfections or racially asymmetric market failures. The free market under a neoclassic ideology, a free and fair meritocratic market, requires everybody to be a profit maximizer, everyone to to be perfect competition, which would mean that everybody gets to enter any market they choose or leave any market that doesn't serve them, right? And that requires capital, right? A free and fair market, a perfectly free and fair market, would have perfect information. Everybody knows everything about everybody and everything. And it would have zero transaction costs. Those are the four pillars of a free and fair market that is described or relied upon by what's called free market fundamentalists. However, we know that those presumptions do not exist. And not only that, we know that the free market imperfections are also racially asymmetrical. So when it comes to perfect competition, yes, obviously those with more capital can compete than those with don't. So the racial wealth gap shows that these imperfections, this lack of capital, is asymmetrical between race. And that's before we even split capital up between human, social, political, and financial capital. We'll talk about political capital in this rubric in a second. Same with information. Obviously, information is imperfect, so the free and fair market cannot exist with this imperfect information. However, we accept that government's role in making information more perfect by having public education, by penalizing fraud in other ways. However, we know that these imperfections in the marketplace are racially asymmetric, both with respect to information available to black folks and information about black people, otherwise I call the myth of black inferiority, or racial stereotyping, as some of you may call it. They all represent asymmetrical market information relating to race, right? And we can recast it that if we take, let's say, Desiree Kennedy's article from back in the day talking about stereotyping in the entertainment industry, right? It was a harm to those that experienced it, but we also know that it perpetuates racism into the future. It perpetuates the racial wealth gap into the future because it exacerbates asymmetrical market information about black people and further denigrates a would-be and otherwise would-be fair and free market. Sorry. Also, transaction costs. A free and fair market, there's none, right? The neoliberal, the dream, the perfect, the capitalist dream is that there's no transaction costs. But again, we know there are taxes. We know there are externalities, right? And we know that again, they are asymmetrically distributed. When we talk about crime, health disparities, environmental pollution, and we can talk about a host of other things that are described as societal transaction costs and externalities, and show that they are inequitably distributed to black folks. My last book, Taxes, Death, and Trouble, talked about racist and regressive taxes, both formal and informal. They would be reflecting asymmetrically distributed transaction costs of a racial nature. And then the fourth, which is actually the first, everyone is expected to be a profit maximizer. But we also know that everyone would not, you're not going to sell your children for the right price. There are limits, right? However, black folks are more discouraged from participating in the marketplace than others. And some of it can be a voluntary withdrawal. Black folks are maybe more altruistic, as has been shown when it comes to income and wealth levels. So as whether the refusing to engage is from a place of capitulation, an alternative place of morality, or because of discouraged through society, we know that that the asymmetrical nature of market profit maximization and market engagement will perpetuate the racial wealth gap and exacerbate it into the future, right? So that's the framework. Asymmetrical market competition, racially asymmetric market information, racially asymmetric transaction costs and externalities, and then racially asymmetric profit maximization or market engagement. And it is my belief that just about every racially subordinating circumstance can be fit within that rubric to describe how racism denigrates a free and fair meritocratic market. So America cannot have a claim to meritocracy so long as racism is about. It can't have a claim to having a free market. It's funny how they say the free market will eliminate racism when it's the opposite. You can't claim to have a free market so long as there is racism, right? And it also shows how racism will perpetuate itself, which is consistent with the new trend towards describing racial capitalism, just from a different perspective. All right, so that's the framework, right? That's the framework. Racially asymmetric market competition, racially asymmetric market information, racially asymmetric transaction costs and externalities, and racially asymmetric commitment to profit maximization or market engagement. Those are the four things. And every paper that we do here, every paper that we review, we're going to categorize it into one or more of those categories. And it's my belief that the ease with which it fits into a category, the ease with which it fits into several categories, also relates to how serious a public response should occur, because it is denigrating, it is a drag on the economy as a whole. That's where interests should converge, whether it's recognized or not. All right, so featured this week. All right, we took long enough to tell you what we're going to feature this week. We're going to feature three fantastic articles that we've pulled. One, Dobbins-Baxter from University of Tennessee, and she speaks on racial health disparities, and I'm going to recharacterize that as asymmetrically distributed societal transaction costs and externalities. Racial health disparities, also to the extent they're based on stereotypes about blacks in pain, they also represent asymmetrical market information about black people. She's published this. Her article is entitled Dying for Equal Protection in the 71st volume of the Hastings Law Journal, page 535, 2020. The second paper that we'll discuss is Wieber-Lens from Arkansas-Fayetteville, and her discussion of punitive damages, and I recast that as asymmetrically distributed societal transaction costs and externalities. We'll describe how we get there in a second. Punitive damages, civil damages are set. They are by juries that are empowered by legislatures and the courts to set the costs of untoward or unwanted behavior. right? A tort is a harm, and the damages are the cost that are imposed on you for engaging in that transaction. So that's why we're calling it a transaction cost. However, to the extent damages are asymmetrically distributed, and to the extent that black folks receive less for the same harms, we're going to call that asymmetrically distributed societal transaction cost. And then the last paper is by critical race theory veteran Girardeau Spann out of Georgetown, and his paper on racial gerrymandering, and we're going to consider that as asymmetric competition in the market for law and regulation. Instead of, we're usually talking about the commercial markets, and in that respect we could label this asymmetrical transaction cost when we talk about political gerrymandering and vote and the right to vote, right? Because the legislature is the place where societal transaction costs are distributed. All of law is about a redistribution of wealth, right, or the distribution of that wealth. And here, when we talk about gerrymandering, poll taxes, etc., we are talking about we are guaranteeing basically the asymmetrical nature of those transaction costs. Now, but it seems to me that we're talking about that competition. We're talking about competing over what law and regulation is. And that is still compatible with neoclassical economics and the type proposed by, let's say, James Buchanan and those that promote public choice theory, right? That mark the regulation, law and regulation is also to be competed over, that there is a market for it, and that each group or faction should compete for it. And therefore gerrymandering and reducing our vote would then be less political capital to compete with. So as much as competition for law and regulation is imperfect, it would be asymmetrically imperfect with respect to black folks because of the political capital gap. He's published this, what he entitles Gerrymandering Justiciability in the 108th volume of the Georgetown Law Journal, page 981. Oh, I'm sorry, and Jill Wieber-Lens, the last paper, is entitled Children, Wrongful Death and Punitive Damages, and this is the 100th volume of the Boston University Law Review, page 437. All right, just going to remind you of some of the papers, the articles that we've done in recent weeks, just for those economic justice scholars interested in the hot stuff, the hot plays that are out there right now. We talked about Anya Prince and Daniel Schwarcz last week. Proxy discrimination in the age of artificial intelligence and big data. And one of the great things about that follows upon Jason Bent's algorithmic affirmative action. Is algorithmic affirmative action legal? This issue of machine learning, of artificial intelligence, is hugely important to economic justice scholars, and I'm very glad that these papers are out there. Not a law paper, but if you're interested in this topic, you really should also get Ruha Benjamin out of not Rutgers. I want to say Ruha Benjamin is either at Rutgers or Princeton. I want to say Princeton, but it could be Rutgers. Anyway, her book is fantastic regardless. The New Jim Code. The New Jim Code, talking about machine learning and algorithms and the perpetual racism thereby. Last week we also talked about, discussed Paul Mastrand and Nick Merkay, fellow tax crits, on racialized tax inequity, wealth racism in the U.S. systems of taxation. Anytime we got to talk tax, I got to give a shout out to my mentors, Beverly Moran, Dorothy Brown, Karen Brown, and John Powell, all those that promoted taxation and critical race tax theory, right? Dean Alice Bullock, who was the dean of Howard University Law School when I was attended. Alice Thomas, Kiva Teri, right, my colleague, shout out. We also talked again about slavery by another name, or I'm sorry, what Noah Zatz from UCLA entitled his paper, I called it Slavery by Another Name. He calls it Get to Work or Go to Jail, State Violence and the Racialized Production of Precarious Work. I call it Slavery by Another Name, or the 100% tax on black labor, right? Whether it's slavery, whether it's sharecropping, or whether it's prison labor where you only get 25 cents an hour. We can categorize all of them similarly as near 100% taxes on black labor. So so you can distinguish the violence, you can distinguish the level of control or pain, but economically, we can see how tantamount they are to each other when we describe them in the form of a tax on black labor. Barry and Weiner, ex-offender housing, stigma and discrimination. Crozier and Garrett, driven to failure and empirical analysis of driver's license suspensions. Malika, on the unfinished mission of Title VII, Black Parity in the American Workplace. Peter Nicholas, Reconstruction, and that reconstruction is about the reconstruction of civil rights laws by the judiciary, not necessarily just about the Reconstruction Amendments. Sable and others on the trends in correctional control by race and sex. Fantastic paper, again, when you talk about taxes, death, and trouble. Bernadette Atuahene, out of Chicago, Kent, with predatory cities in the California Law Review. That paper's hot, fire. Predatory cities, Bernadette Atuahene. Also, similarly, Beth Colgan, Economic Liberty and Criminal Justice in the Harvard Journal of Law and Public Policy. So those are the types of papers that we've done over the last 3, 4, 5 weeks. I can go on. But those are the ones of more recent vintage to give you a sense of the papers that sometimes expressly talk about economic justice. On the other hand, could be talking about racial health disparities, could be talking about driver's license suspensions, could be talking about taxation, right? And we can recast them in terms of the correctional control, criminal law enforcement, and we can recast them in terms of economic degradation now and in the future. So let's get busy to the first one. The first one is Dobbins-Baxter, Teri Dobbins-Baxter. She is a tenured professor of law at the University of Tennessee. I want to say she was at St. Louis prior to going to Tennessee. Her paper, Dying for Equal Protection, is in the Hastings Law Journal. My description of it before I get to a piece of the paper is that present and historical racism in healthcare represents asymmetrically distributed societal transaction costs and externalities. Stereotypes and myths upon which racialized healthcare decisions are made reflect asymmetrical market information about black people and people of color. The school to prison pipeline, as a proponent of racial health disparities as she identifies, also reflects asymmetrical market information available to black people and people of color. So when we talk about asymmetrical market information, we're talking about two major components. The information available to black folks, and that's when we talk about racism in education. That's when we but then also information available about black folks, and that's where we talk about the myth of black inferiority. Now, as an Afrocentric scholar, I can locate both inside public schools when we talk about the lack of truthful information and also its perpetuation of the myth of black inferiority through Eurocentric concepts and the rejection of Afrocentric historical facts and theories. All right. More about the paper, and I think it's a great paper. It features some eminent scholars in health and law, such as, of course, Michelle Goodwin. She refers very prominently to Dana Matthew Bowen's Just Medicine, A Cure for Racial Inequality in American Healthcare. So first, let me say congratulations to Professor, Dean Bowen, who I believe has just moved from, first she was at University of Colorado. I think she's now, then she's at UVA, and then has moved from there to becoming the new dean of the George Washington School of Law in Washington, D.C. So shout out to Dean Bowen. But now, as good as this paper was about the history of racism in American healthcare, it would have probably been a little more fuller, and I was looking for more citations or discussion of David McBride's work. I know he's not a law professor, but when you talk about the history of healthcare and racial healthcare in America, he's been writing on it since the 80s. So David, I believe he also has a book out in 2018 even though I think he's semi-retired, Caring for Equality, A History of African American Health and Healthcare. So, along with Michelle Goodwin and Dana Matthews Bowen and Teri Dobbins-Baxter, if you're interested in the subject, I also highly recommend that you check out the works of Penn State University professor David McBride, who has been writing on black folks, and especially today. He has a book, I want to say he published in 1991, called From TB to AIDS, talking about the response of the federal government when it comes to blacks and pandemics. And similarly, with Professor Dobbins-Baxter, he also talks about lynching and all that. So the similarities between the two are great. And I think it would be a very good complement to this paper. Also, I found impressive was again, for economic justice scholars, I think I was cognizant of it, but I have not used it enough in my own writing. She cites Frank and Monroe's The Original Understanding of the Equal Protection of the Laws, published in 1972, for the notion or for the support that the equal protection clause should be interpreted far more broadly than how it's being interpreted now by the current Supreme Court. Let's do a little piece from the paper, from Teri Dobbins-Baxter's piece in Hastings Law Journal, Dying for Equal Protection. When health policy experts noticed that health outcomes for African Americans were consistently worse than those of their white counterparts, many in the healthcare community assumed that poor outcomes could be blamed on poverty and lifestyle choices. Right? That's the myth of black inferiority that we're talking about. Subsequent research told a different story. Studies repeatedly showed that neither money, nor marriage, nor educational achievement protect African American men, women, or children from poor health. Instead, the disparities were more likely explained by racism. Specifically, multiple studies have shown that experiencing racism has been linked to increased infant and maternal mortality rates, elevated stress levels, and increased risk of numerous diseases, including cardiovascular disease, high blood pressure, and breast cancer. Mounting evidence makes it clear that health disparities cannot be eliminated simply by changes in diet or socioeconomic status. That's an important point. It requires eliminating racism and building a more just society. A just society starts with a just government, but racially biased government policies and practices have existed since the founding of our country and have had and continue to have a direct and devastating impact on the health of African American individuals and communities. This article traces the racially discriminatory laws and policies enacted or tolerated by state and federal governments in America from colonial times to the present, including slavery, black codes, convict leasing, lynching, segregation, and discriminatory policing, and links that racism to poorer health outcomes for African Americans. And that's when she also has to bring in that 14th Amendment, expansive view of the Fourth Amendment, that was intended to go beyond just what we're calling now state action. It concludes by discussing the need for criminal justice and social reforms to explicitly consider their impact on the health of the African American community. We're going to read a little bit more from the paper, just so we can build in some of the things that she's talking about specifically. We won't try not to go too long. In her groundbreaking book, Just Medicine, Professor Matthew explores the impact of racial and ethnic discrimination on health and minority population. She describes discrimination as the single most important detriment of health disparities that is not being widely discussed in straightforward terms. Her book identifies structural racism as a key driver of health disparities, but the book focuses on an implicit bias in the healthcare system and the steps that can be taken within that system to reduce disparities. This article builds on that work, as well as the many social scientists whose research confirms the link between racism and health. However, this article shifts the focus from healthcare providers to the role of the government in creating, sustaining, and fostering racism through explicitly racist policies and racially biased enforcement of facially neutral laws. And there we have again, the equal protection hook. Part 1 identifies existing racial health disparities and discusses research identifying racism as a cause. Part 2 discusses the state and federal government's failure to protect African Americans from discrimination and violence before and immediately after the Civil War. Part 3 explains how state-sponsored and state-tolerated racism allowed violence and discrimination against African Americans to continue for nearly a century from the Reconstruction era until the Civil Rights era. And it explains how that discrimination negatively impacted the health of African Americans. Again, that's where I was assuming that we were going to see some citations, some references to David McBride's work. While lauding the progress toward racial equality in the Civil Rights era, Part 4 laments the racially biased enforcement of facially neutral practices and policies that continue. Part 5 explores how the government's ongoing failure to provide equal protection continues to contribute to racial health disparities. And finally, Part 6 argues that because racial health disparities are largely the result of long-term government action and inaction, eliminating the disparities will require government action to prevent discrimination and lessen racism-related stress. To this end, those who are working on social and criminal justice reform must consciously consider and study the effect of reforms on the health of racial minorities. She concludes, racism is a long-standing problem in America, and for as long as it has existed, it has brought about emotional and physical pain to its victims. The racial health disparities that we see today are the product of racist policies and practices throughout our nation's history. Working solely to change the hearts and minds of individuals will not solve the problems that lead to poorer health outcomes and shorter life expectancies for African Americans. Just as government actions have contributed to the problem, change at all levels and with all branches of government is necessary for healthy African American communities. Now, of course, as I agree, I'm an economic justice law scholar, and not just that, but one that follows, that believes that Derek Bell was correct when he talked about racial realism, when he talked about interest convergence theory, when he even talked about the rules of racial standing. So, it is, as much as it is the responsibility, as much as government ought to do the things that Professor Dobbins-Baxter is requesting, we know that interest convergence suggests very strongly, and I agree with it, that we will only get these things to the extent it is compatible with the wishes and the interests of elite whites in the society. And decades after Derek Bell wrote that, Citizens United has absolutely certified and petrified that within our legal, socio-legal, economic environment, right? That if you have the means, you control law and regulation, and therefore the civil rights laws will advance only to the extent, if and only to the extent they advance the interests of elite white folks, which again for me requires then a nationalistic response. Better educate ourselves, start patronize black business, and stop until we criticize each other. You know the drill. All right, that was number one, paper number one, Teri Dobbins-Baxter. Paper number two, Jill Wieber-Lens. Her paper, Children, Wrongful Death and Punitive Damages, in the Boston University Law Review, page 437 of 2020. This paper is not necessarily written with respect to race. However, she does mention it in it and as part of, as support for why we should not rely on pecuniary damages. So my description of it in terms of racially asymmetric market failure is this. As part of her argument against damages based on potential lifetime earnings, Professor Wieber-Lens refers to disparate civil damages for the deaths of black children, which reflects asymmetrically distributed societal transaction costs and externalities. Again, when we talk about transaction costs, you can either talk about the actual harm of pollution, of accidents and other torts, or we can talk about the price that the jury or judges set, right? I voluntarily ran you over. And therefore, the court on the back end, and the jury is on the back end going to basically set the price for that action. So instead of I'm just going to run over you and you have nothing to say about it, we're basically establishing a post-ante contract that for $225,000 of damages, you get to run over this person. right? Again, that's another law in economics idea that law sets the price for activity. Outside of the market price. It can either add or subtract, right? We can subsidize or we can add on. So from the paper, Children, Wrongful Death and Punitive Damages, she writes, starting in the mid-19th century, state legislators created wrongful death claims, including claims for bereaved parents against the tortfeasor who killed their child. Legislatures limited recoverable damages to pecuniary damages, meaning parents could recover the lost economic contributions they expected to receive from their child during his minority, minus the cost of raising the child. That's pretty antiseptic, right? That pecuniary damage measure still controls today, with most states now also allowing recovery of non-economic loss of relationship damages, although many states also cap the recovery of non-economic damages. In some, parents' recovery of damages for their child's death, a personal and cultural tragedy, is limited to pecuniary damages which today's parents lack, and a possible capped non-economic damage award. This article suggests the adoption of a remedy consistent with the current tragedy of child death. That remedy is the exclusive use of punitive damages in wrongful death of children cases, a remedy for parents that is actually a substantive response to the death of a child and that could provide parents something significant and meaningful. Private redress punitive damage theory explains that punitive damages empower victims by enabling them to obtain damages for the moral injury suffered. Similarly, parents should recover punitive damage for the moral injury they suffer when their child is tortiously killed. The appreciation that parents suffer a moral injury better encapsulates parents' actual experience, an experience from which parents do not want to be made whole, and one that involves much more than grief. Also, punitive damages, unlike compensatory damages, actually express the wrongfulness of the death of a child. However, we know that she wants to switch from an economic loss, proving economic losses, to pecuniary, to punitive damages, to redress the hurt, redress the harm. I mean, the unreal hurt of a parent losing her child. I believe in her paper, she makes the point that there's not even a term for a parent that loses a child because it's just so horrible. It's not like widow or orphan or what have you. A parent loses a child is so rare and it's so painful that we don't even have a word to describe those folks. But in pushing for punitive damage rather than pecuniary damages, she does in fact point to the fact that black folks, that economic damages are not only unfair from a general sense, it is also unfair or from a gender and racial perspective. She writes, the supposed solution to the speculation problem is statistical data. A fertile area in cases of young children lies in the use of statistical averages. For example, figures can be obtained and presented showing average earnings of grammar school graduates, high school graduates, persons having 1 year of college, and so on. Right? Actuarial science, right? We know about actuarial sciences in insurance companies and all types of other stuff. But the use of gender-based and race-based statistical data, however, creates a larger problem. And this is also, again, we talk about machine learning and algorithmic learning, and how machine learning and algorithmic learning, artificial intelligence, perpetuates racism based on past racism, right? This is how. As numerous dedicated legal scholars have argued, the use of gender-based and race-based tables is discriminatory. Because of wage discrimination and occupational segregation, predictions of future earnings for women and minorities are considerably lower than for white men, even when controlled for such factors as educational attainment. Thus, the projected lifetime earnings discounted to 1990 present value of a female college graduate have been estimated to be only 65% of those of a similarly situated male college graduate. The use of statistics in this context means that current race and gender disparities in wages will be projected into the future, and that bias in the setting of wages will continue to influence personal injury and wrongful death awards. In 2015, Judge Weinstein of the Eastern District of New York refused to use a race-based table to estimate damages for a 4-year-old permanently injured after inhaling lead paint dust. This issue often arises in lead paint cases, right? Again, race cases, because low-income and minority families are more likely to occupy older homes with lead-based paint, meaning the majority of children poisoned by lead in the United States are poor African American and Latino children. In the specific case, the defendant's attorney wanted to use expert economic testimony based on race-based data to show the improbability of the Hispanic child obtaining a bachelor, master's, or doctoral degree and any corresponding elevated income. Judge Weinstein excluded the evidence, finding the use of race-based tables to be discriminatory. But know that the Supreme Court has found such actions to be themselves against equal protection when you are, or so-called reverse racism, when you are trying to correct racial subordination by taking conscious evidence of it. A few dedicated scholars are set out to ensure that he is not the last. The possibility of discrimination is a very good reason to be wary of the loss to a state measure of economic damages in a wrongful death of a child case. So that is why the paper Children Wrongful Death and Punitive Damages belongs in a blog, in a review about race, economics, and the law, because the argument to move from a economic damages to a punitive damages is in part justified by the elimination of gender and race asymmetries in the distribution of societal transaction costs and externalities. All right. Our last paper is from Girardeau Spann, a longtime critical race theory veteran at Georgetown Law, and this is also published in the Georgetown Law Journal, entitled Gerrymandering Justiciability. Right? In other words, for my con law and my administrative law folks, or I'm sorry, for my non-con law and non-administrative law folks, he's talking about the willingness of the judiciary to hear cases about gerrymandering rather than simply punt to the political arenas, right? In many instances, the Supreme Court will say that certain things are strictly political questions over which the judiciary is not competent or not authorized to second guess the legislature. And gerrymandering, partisan gerrymandering, is one of them. Racial gerrymandering is something that the court will review, or says it will review, and is justiciable. However, Girardeau Spann, he doubts that. He questions that. He criticizes that in true critical race theory style. So, first of all, my description of the economic consequences of racial gerrymandering. Spann describes how the Supreme Court refuses to review racial gerrymandering when under the pretext of interpolitical party competition, but may review interpolitical party gerrymandering under the pretext of reverse racism. Since the political arena is where costs are imposed and distributed, the dilution of black voting power through gerrymandering, informal taxes, and other voter suppression tactics reproduces racially asymmetrical societal transaction costs and externalities. Because again, the legislature, the voting booth, is where we ultimately decide the cost of societal transactions and externalities, whether to subsidize them through payments and tax deductions, or whether we penalize them and increase the cost through criminal justice penalties, through civil damages and other means of fees and or fines and other tactics. However, we can also recast this as asymmetrical competition for law and regulation, right? We can say that the lack of political capital, or the gap in political capital, represents asymmetrically imperfect market competition. Competition for what? Goods and services? No. Competition for law and regulation. That is compatible with public choice theory, which is compatible with Citizens United, right? The idea that law and regulation in a democracy with factions is to be competed over, and the resulting product will be respected by the courts as the referee of a fair fight, right? Again, the racial wealth gap shows expressly why it's not a fair fight, but we can also talk about, again, the asymmetrical imperfections in information. When we talk about the market for law and regulation, we can also talk about racial violence and other things as the transaction costs that we've historically had to pay, or even the poll taxes and all that as far as the transaction costs for trying to get law and regulation. So even if we were accept a free market of ideas, a free market of law and regulation, as well as a free market. I mean, it could be a free market for sex or a free market for goods and services. Any way we want to describe a free market, you can talk about its degradation as far as in terms of imperfections of the free market assumptions. And then we can also talk about the racially disparate or disproportionality by talking about how those imperfections of the market for goods and services, for law and regulation, in the marketplace for ideas, that the structure of that market is asymmetrical with respect to racial competition, information, transaction costs, or even commitment to profit and engagement. All right. So let's talk strictly from the paper. Speaking of words strictly from the paper, while I'm getting all clogged up, I apologize. From the words of Professor Spann directly, the Supreme Court has gerrymandered its justiciability doctrines in a way that protects the political power of white voters. Comparing the court's willingness to find racial gerrymanders justiciable with its refusal to find partisan gerrymanders justiciable reveals a lack of doctrinal restraint. That gives the court the discretionary power to uphold or strike down particular gerrymanders by deeming them racial or partisan in nature. And again, discretion. For those of my administrative law folks, we know that racism lies within discretion, and it is hidden by the false commitment to formalism, which suggests that you don't have a choice, that suggests that law and regulation is mathematically derived at without discretion. Anyway, that gives the court the discretionary power to uphold or strike down particular gerrymanders by deeming them racial or partisan in nature. Such discretion is problematic because when the Supreme Court has exercised discretion in a racial context, it has historically done so to protect the interests of the white majority. And that appears to be what the court is now doing again in allowing white Republicans to dilute the political power of minority Democrats. In Rucho versus Common Cause, the Supreme Court treated the constitutionality of partisan gerrymandering as non-justiciable. In Shaw versus Reno, the Supreme Court treated the constitutionality of racial gerrymandering as justiciable. But in Easley versus Cromartie, the court held that what appears to be racial gerrymandering can actually constitute partisan gerrymandering. So how does the court decide whether a particular gerrymander is non-justiciably partisan or unconstitutionally racial? Right? How do they do that? Well, according to Spann, it turns out that the arguments on which the Supreme Court relies to support its justiciability distinctions between partisan and racial gerrymandering can be inverted in a way that supports the equally plausible conclusion that partisan gerrymandering claims are justiciable and racial gerrymandering claims are not. That lack of doctrinal constraint gives the Supreme Court considerable discretion, and by gerrymandering the line that separates justiciable from non-justiciable claims, the Supreme Court will have succeeded in helping whites to preserve the political advantage that they have over racial minorities. Part 1 of this article describes the Supreme Court's justiciability rules for gerrymandering claims, just like we talked about the Reno case and the Rucho versus Common Cause. 1A explains how the court finds gerrymandering claims to be non-justiciable. Part 2 inverts the court's justiciability rules, showing how they can be applied in a way that produces the opposite of the results that the court found them to produce. Part 3 argues that the court's gerrymandered justiciability decisions create a sphere of unconstrained judicial discretion that the court will end up exercising in a way that protects white electoral advantage from the threat of equalization through either partisan or racial gerrymandering. And this article concludes that neither political party nor judicial efforts are likely to secure electoral equality for either political or racial minorities, because the Supreme Court will not compel the mathematical proportionality that offers the only realistic hope of ever achieving the equality needed for genuine democratic self-governance. In the final analysis, it may be that the rule of law safeguards that are supposed to protect racial minorities from the discriminatory inclinations of the culture in which they live were never intended to provide anything but false hope. Right? That is in stark contrast to Teri Dobbins-Baxter, right? Teri Dobbins-Baxter gives us a history of racism in healthcare and puts it on all branches of government to fix it. However, Gerrymandering Spann, a very long-time veteran and critical race theorist at Georgetown, this paper could be probably linked with other so-called Afro-pessimists. Please read Frank Wilderson out of Stanford. I think it's out of Stanford. Frank Wilderson has a great book about Afro-pessimism, right? That this one, on the other hand, says no. Because the way in which the Supreme Court and other government actors use their discretion, just as Derek Bell predicted, in the service of elite white culture, suggests that the rule of law safeguards that are supposed to protect racial minorities from the discriminatory inclinations of the culture in which they live were never intended to provide anything but false hope. Now, the only thing I can pick out in that one is maybe they were originally intended from that to do that. And since then, since the neoconservative assault on civil rights in the 1980s, have been successful and retrofitted those rules. So whether, now it may be, I may be splitting hairs on whether it was the original intent or whether it's been co-opted. I will agree with Professor Spann in the end that that black equality, and whether that is in the marketplace for ideas, the marketplace for law and regulation, the marketplace for goods and services, are going to have to amass human, social, political, and financial capital to affect any type of equality or even just dignity, if that's what we're looking for. And I say that to say that there's a new book, and maybe we review it next week, that's out by Gene Sterling, former director of the Council of Foreign Relations, and is not talking about race, but he's talking about income and wealth inequality in America and a call for economic dignity. That even if your goal is not to equalize wealth, even if you think, and most anthropologists do, that social inequity is a hallmark of society. That's right, that social stratification is a hallmark of civilized society. Even if you believe that, his argument is that there are limits and that economic dignity needs to be a, if not a major, then it needs to be the principle on which legislation is enacted and I guess interpreted. I've not read the whole book, but I just wanted to put that out there, that on top of these 3 papers, there's also a great book out right now called Economic Dignity by Gene Sterling. I'm sorry, there's another book out there, although it fits a little less neatly within this rubric, but Isabel Wilkerson, Migration to Better Suns, I forget the title, about black folks, the warmth of other suns, about black migrations from the south to the north. She has a new book out called Caste. The origins of our discontent, if I got that off the top of my brain. Woo! That's a book that I really need to check out. And then maybe if I can do that, we can review that next week for next week's Economic Justice Law Review weekly scholarship presentation. So look for that next Wednesday. This is Andre Smith, Smitty Bonton. I hope you enjoyed the 3 that we've done today. Dobbins-Baxter's Dying for Equal Protection, Wieber-Lens's Children, Wrongful Death and Punitive Damages, and then finally Girardeau Spann's Gerrymandering, Justiciability. All right, see you next week.